You guys are good. Everyone's hopping on. They're just they're all muted, but they're.
We have a lot of folks who've not
I have one
connected up yet.
Random letters and numbers.
Okay. All right. Hello. This is Larry Krasner. Thank you all for being here. So I'd like to explain for a moment how to proceed in this fascinating Zoom conference. I will speak for about 5 minutes. Our public defender, Keir Bradford-Grey, will speak for about 5 minutes. We will take any questions after that point, and we would ask you to email your questions to Jane Rowe, who is right here with us, and then Jane will provide us the questions and we will provide the answers. This meeting is being hosted and therefore everyone on the meeting is muted other than the person speaking, which is of course me at the moment. We are going to record this just so there's no confusion about what was said or not said. And let me just get started then, if I may. So there have been some very extensive efforts, in my view. Obviously, I will not speak for the public defender, but I doubt that she will disagree. There have been some very extensive efforts by both the public defender's office and the district attorney's office going back about 3 weeks to address the crisis that we face now in terms of trying to reduce the population of inmates in county custody in Philadelphia. From my perspective, the purpose there was to protect public safety. And I emphasize public safety because we care about all lives and naturally we care about inmates as well. But when you're dealing with a pandemic, you're dealing with the reality that the spread of the virus in any community spreads it in all communities, and that we are all endangered when a cruise ship has an outbreak, when a senior center has an outbreak, and when a jail has an outbreak, and when a bunch of billionaires attend a cocktail party and spread the virus at the cocktail party, they have an outbreak. It is obviously a pressing issue, and I think public defender wisely pointed out earlier that in some of these emails between us and the court, that a lot of good work has been done and has been done over the last several years with the MacArthur Foundation, with a lot of stakeholders, including before I showed up, to bring a county jail population down from 10,000 to the more manageable, but still very troubling in this pandemic level of the mid 4,000s. So what has happened over the space of 3 weeks, in my view, is that these two offices have been in communications, have collaborated, and have been pressing one way and another very deliberately and very specifically for a streamlined proceeding that would allow the judges who have the power to lift detainers, who have the power to lower bail, who have the power to grant timely parole, late parole, or early parole. We've been working to have a streamlined way of finding the right candidates who, at least in the view of the DAO, don't present a threat to public safety and can be released in order to reduce a different threat to public safety, which is the threat to public health safety. Judges have this power uniquely. District attorneys and public defenders, of course, can make their recommendations and their requests. Our efforts to do this in a streamlined and sweeping and efficient fashion have been frustrating. and they have been frustrating because the position that has been taken by judicial leadership, as they call themselves, is a position that every individual needed to file a written petition, that there needed to be a response in writing in one form or another before there would be a decision by the judiciary. We, on the other hand, were proposing, let us have lists of people in categories that are likely to be appropriate for release, and let us do a whole string of hearings. For example, consider 100 people in a day after both offices have reviewed those files and see where there's agreement, and also allow the court to do its role, which is to make a decision on that without all of this wholly unnecessary written motions practice in a coming and then arriving and now crushing pandemic. That's the position we've taken now for quite some time. Our idea from the beginning with these lists has been to identify appropriate categories. And there's been much discussion about this and substantial agreement between the DA's offices. Those lists are groups like the following. Number one, and I'm not saying in order of importance, but number one, people who have already completed their minimum county sentences. People who ordinarily would have their judge likely already ordering parole, but can't do it now because the courts are closed and because the judicial leadership holds all the power due to the emergency powers. People who have not completed their county sentences but are serving county sentences and are within a certain period of time of their minimum date. We have proposed taking a look at people who are within 6 months of their minimum date to see which ones among them may be appropriate. People who are on relatively low bails. That's another category. And we have screened out from that category violent offenses, sex offenses, drug offenses, gun offenses. We have also suggested, and there's been some agreement, to take a look at women with children, or I think the defender proposed more broadly, take a look at all the women who are in custody, which is not a very, very large population. There has been discussion of looking at people who are held on technical detainers. In other words, they have not been charged with any new offense, but they fall within a category of probation or parole violators or potential violators who may have had a positive test for marijuana in their blood. They may have missed one or more meetings with their probation officer. Perhaps they didn't pay their supervision fee or comply with some other condition. We have suggested one step away from that. Can you hear me, Keir, or no? Can other people hear me or no?
I can hear you. There's some noise that keeps popping up, like someone's scratching or chewing some chips or whatever. I don't know.
Well, I'm sorry. It's not happening here. I can tell you that.
All right.
But I apologize. So, another suggestion has been to look at people who have detainers for potential direct violations, but only where those direct violations are relatively minor. For example, people who have open misdemeanor cases that do not include sex offenses and they do not include violent offenses, who may be on probation or parole for something else. The idea is not that all these people should get out. The idea is that there should be a rapid, case-by-case analysis in an efficient way. And in the world that has been proposed by the defender and by the district attorney's office, and Keir will, of course, correct me if I'm wrong, what that world looks like is a group of judges. Could be 5, could be 10, but a group of judges, could be 20, because let's be honest, the judiciary, like the DA's office, is getting paid, and the courts are not open. So it could be a large number of judges, perhaps, let's just say 10, who are handling a substantial list of cases. Let's just say 50 to 100 cases each in a day, and they are making decisions on those cases without piles and piles and piles of paper or virtual paper. The result is you simply need an order for each defendant, and decisions to release or not are made in an expedited and efficient way. That is the world that the public defender and the DA's office have been fighting for some time, and fighting, I would say, respectfully, and that is not the world that we have been getting. We are pleased to see that we are getting some, not as much as we would like, but some of what we've been asking for a long time, even if it is, frankly, later than it should be. We're pleased to see that. It's going to be starting on Tuesday, but you need to know that both the public defender and the DA's office offered to do it today. We offered to do it Saturday. We offered to do it Sunday. We offered to do it Monday. And we offered to do it the day the courts have chosen to start, which is Tuesday. And frankly, we would have done this 2 weeks ago, a week ago. That's the reality. We are not interested in looking too much in the rearview mirror, other than the public is entitled to know the real history of what happened here. We are much more interested in looking forward, because when you look in the rearview mirror, you crash the car. And what we would like to see looks more like this. So for example, despite the portion of the release that suggests that the courts have not received a list, well, actually, just to give you one example of a list, they received 7 lists by emails. And yes, everything that we are saying is confirmed by emails. And yes, if you need to see those emails, you're welcome to see those emails, because they say what they say. But there were, in fact, after days of heavy data work done by the DA's office in collaboration with the public defender's office, there were 7 different lists that were provided to the court for them to consider. They are more or less the categories I just told you. And those lists total 1,997 individuals, that unique inmates, that we thought were at least worthy of consideration. It's not to say that both sides would support the release necessarily. For some, maybe not. But they were categories where a high percentage of these folks, under these particular circumstances of this pandemic, would be likely for release. They have those releases. They have those lists. They have had those lists for some time. You want to see those emails, you're welcome to see it. I know that the defender has also proposed some lists. The first time that we were given any clear indication by the judiciary that had been so opposed to this sort of a streamlined approach that didn't involve individual motions and this very cumbersome process was a press release that was released, I guess, the middle of this week. And as soon as we saw it, I sent off a list of 93 cases for their consideration, because frankly, having said that, for me, the biggest issue is this. The system, we are glad to see any progress in the right direction. We don't really need to spend our time on the history, but the progress that they are talking about, which could be made today, Saturday, Sunday, Monday, which will only be coming on Tuesday, amounts to 4 times 30, 4 courtrooms with a list of 30 cases, when we believe that the system can and could and should have already done a lot more. We proposed looking at 1,997 people. Okay, that is something that, frankly, if you had 10 judges, and I repeat, a lot of good judges are getting paid to stay at home, that if you had 10 judges who are considering even 50 cases a day, which is sort of like a normal municipal court list, could be knocked out in 4 days, including days on the weekends. So we applaud the fact that there is a mechanism for a more streamlined approach. We look forward to it being expedited, and we hope expanded, so we can get through this. And I frankly am very happy to have had the collaboration and the cooperation of Keir Bradford-Grey and certain people at the Defender Association and certain people here. The people here who have really borne the greatest load have been Liam Riley and Dana Bazelon, who are available. They're sitting right here, and they're available if you have specific questions. I know that some of the people at the Defender's office who have borne the biggest load, because they've been in our office and we've been in communication with them a lot, include Sarah Allen and Jordan Barnett, and also John Gross, who's one of the policy heads at the Defenders, and he's been involved in discussing some of the categories. But the truth is, Keir herself has been heavily involved in this. We've communicated a lot, and I think it's been very constructive. So I'll be quiet now and let Keir jump in. You unmuted?
So I agree with everything Larry has just said in terms of this, the frustration with the process. I will say this, there was a meeting that was held prior to the court's closing that really kind of stressed the urgency of this issue. I was not present, unfortunately, for that. Since the courts have closed, I have asked for more communication around what our plans are. I would really like to see more of the Justice State Code leadership offer some plans to help expedite the release of people that I would say in these categories would probably be released if the courts were open. I mean, we're talking about people that are at their minimum date that should be released. We're talking about people that are in on very low level circumstances that we would be filing motions for on a regular basis if the courts were functional. We can't do that. So we really need the courts to be more open to understanding what the situation is, the direness of the situation, the fact that the prison population positive test is growing rapidly day by day. I still don't understand how we're getting the most recent and real information on who is testing positive each day. But right now we know we have 31 that has been reported. There is no way to social distance in jails. There isn't. So all we know is that's just going to continue to rise. And so if we don't act now, we can't wait till next Tuesday and next week and the following week. We've got to act today, tomorrow. And like Larry said, we're available to do that. I was really taken aback to see the quotes that were in the paper today by the courts, because that is not my recollection at all, that anyone is sitting around waiting for lists. In fact, we have at the Defender Association about 35 to 40 lawyers drafting petitions, which take about 45 minutes to an hour each to do. We've done well over 300 petitions in our office, and sometimes we were told that we had to redo a good number of them because they weren't in accordance with a now new rule that has come out. So this has been something that has set us back from getting people released, all while people are being threatened with serious harm from this virus that is spreading like I don't know what in that jail. And I mean, I don't know what, because I actually don't know what. It's moving forward. I really hope that the leadership in the judiciary, the DA's office, the public defender's office, the prisons, whoever, really work together to be much more communicative, that is communication that's consistent, as well as a meeting of the minds and goals for us during this pandemic, which there's no playbook for. There's no rules, there's no like, what did we do before? This is a specific and unique situation that we have to be addressing day by day. We can't sleep on and say, I'll do, 5 o'clock, things are over, I'll deal with it tomorrow. I'm sorry, this is a constant. It's been a constant for my office. I'm sure it's been a constant for Mr. Krasner's office. We work weekends, we work beyond 5. We are emailing constantly, nights, mornings, to really get this moving. But we can't do it alone. The only people that have the power to open up those gates are the judiciaries. And I don't mean open up the gates of the jail, open up the gates of a process. So going forward, we do hope that anyone on this can help us with our plea to really look at this as a real public health situation, not just for the inmates in there, but for the people who work there, their families, all of those things that we have seen precedented in other states that have had this problem actually happen and is happening now. Our courts are closed for another month. We don't have any redress to get people out who should be out, who can be out, and who would be eligible to be out if our courts were open. The only way we can do this is by reaching an agreement with the courts to actually create processes for us to do it in more large-scale fashion for those who fit the criteria of really what we call no-brainer people, and more expeditiously. While that's going on, our office is going to continue to file petitions for the people that may have a little more explanation that the court may need for better decision making. But these things can happen simultaneously. And I just don't think people are seeing the urgency. And I say people, all of our stakeholders seeing the urgency and really kind of clearing out, bringing that population down much more than it has been over the last 3 weeks. Because if we had gotten started on this 3 weeks ago, I don't think that we may have the spread that we have now, because people would have much more opportunity to social distance. They wouldn't be two to a cell. They could possibly be in one cell. I don't know what supplies look like in that prison, but I do hear today that prisoners are going to get masks. So it's something that's dire, and it's something that needs to happen right now. But I am very disappointed with the characterization in the paper today about what's been the holdup in this process.
All right. Thank you, Keir. I hope you can all hear that. In other words, hear me. So if there are questions, would you please email them to Jane Rowe immediately and she'll read them off. While you're doing that, I just want to point out something that that Public Defender Gray and I actually discussed while we were getting ready for this conference, which is that the level of reduction in the county jail population in San Francisco is about 30%. The level of reduction in New York is around 20%. And even if we look in Pennsylvania, we see that in Cumberland County, it's about 14%, Dauphin about 12.5%, Lancaster about 9.6%. And yet Philadelphia is somewhere between 6 and 7% on that scale. I can tell you that in Los Angeles, in 1 week, they went from a population of 17,000, more or less, to about 15,300. That is a reduction of 1,700 in a week. It's a reduction of 10% in a week. And they were looking at another couple thousand cases in the following week. I don't know where they are right now. But, you know, my point is simply that we want to now, and we have wanted all along, move efficiently and move as a united front with the FJD and all the other criminal justice stakeholders to make progress. I think certainly in my 27 months, it has become clear, and I'm sure it was clear to Keir even before I showed up, that sometimes progress in Philly takes a little longer than it should. So I don't know if there are any questions. Jane, did you want to recite them? And then I guess.
Yeah, there's a question from Jeremy Robach at the Inquirer. Under the individual case-by-case review that's been happening so far, how many petitions have been reviewed and how many have been released?
Okay, so in case you didn't hear that, under the individual case-by-case written motion approach that has existed thus far, how many petitions have been reviewed and how many people have been released? I'm going to defer to Liam Riley and Dana Bazelon, who've been primary on this, and then I'm going to defer to the public defender for any comment she may have. Do you know?
We have reviewed about 800 cases. Not all of them have resulted in a filed motion yet.
Okay, so we meaning the DAO, has reviewed about 800 cases. Not all of them have resulted in a filed motion yet. Do we know how many filed motions there have been, or how many of these written motions have been granted?
We can work on getting that number for you.
All right, we can probably have that answer for you within a few minutes. They're looking at their data. Can we unmute our public defender, see if she's got something to say?
Yeah, I'm looking through my notes and I do see that in certain categories, I have 3 lawyers that have reported the number of cases that they filed. So cases where people are held in on detainers only, we filed 132 petitions. Cases where people are at their minimum of release, meaning they should have been paroled before this. There have been 95 petitions, and there have been bail cases where people are held in on low-level bail, where it looks like we filed around 114. So that, and remember, we've had to refile a lot of petitions as well. So this has actually slowed us down. So we're almost, at about 400, give or take with that, but we've had to refile about 72 petitions because there were new rules that came down. And these petitions are pretty lengthy. They have a lot in it. We're not only giving them facts that the courts have access to, but we're actually reaching out to program providers, treatment providers, all of these people, and putting that information about a release plan in those petitions as well. We have to redact probation reports, and that requires extra software, extra time to do that so that we can attach it to the single petition. We now we had to also attach the district attorney's response to the petition. So, I mean, these are all extra things that we have to do just to get a consideration on the person. And that takes That's a pretty lengthy process, especially when you're doing it remotely.
Next question.
Next question, and we will try to provide additional answers from Liam Riley and Dana Bazelon to that question for Jeremy
For
Robach.
Jeremy. So the next question is from Sherry Gregg from PYW. How many inmates could be released if the court follows your recommended guidelines?
So the question from Sherry Gregg is, how many inmates could be released if the court follows our recommended guidelines? I guess my answer, and then we'll go to the public defender, but my answer is there's no magic number, but certainly there's at least a couple thousand people who are inmates who are worthy of taking a look. And there may be a second wave of individuals who are worthy of taking a look. So it could be a considerable amount. In my mind, one of the factors to consider is the number of cells that are up on State Road. I have that number somewhere, but I believe it's 1,997 for the men. Thank you, Dana Bazelon.
And 375 for the women.
375 for the women. There's also a bunk room, or there are bunk rooms with a total of 800 beds. If you undertook to use some of them, but to use them with social distancing, perhaps 800 becomes 250, or maybe it becomes 400. But when you total these numbers up, you're looking at less than, even with 400 of the 800 beds, you're looking at a little bit less than 2,500 people. I am not saying that I believe that there's a magic number, because there isn't. We are balancing at the DAO, we are balancing public safety from crime with public safety from health. And they are both very, very serious matters. But certainly, as we get away from the mid 4,000s and closer to a number that starts to look like single cell, and it starts to look like a cafeteria with an empty seat in between inmates who are dining, or if they're dining in their cell, we have social distancing that way. Certainly, we don't have this factory for spread of the virus that we and so many other jurisdictions have now as a direct consequence of mass incarceration. Can we unmute the public defender, please, so she can respond? She's muted.
Okay.
We hear you now.
I agree with Larry. I think these questions should be going to some of the other stakeholders as well, in terms of how many people would it take to be reduced from the prison population to be considered safe or being able to follow the CDC guidelines. That's not really something that I know for sure, but I do know we're trying to make the prisons as safe as possible for the people that are going to be in there. We do know that there's certain populations that are going to be in there, because there's never going to be an agreement to let out people who may seem to be a danger, a threat to public safety. There's not a lot we can do to really flush those things out, because we're not able to have full-fledged hearings to test the evidence or the weights of the case. So we're kind of going by this categorical classification of charges. When we start looking at individuals, we're putting information in about the individual, but of course we know nothing about the strength of the case because we just haven't been able to test that out. I do think that there's, if there's some questions to the prison commissioner, how many people should she have in her prison to create an opportunity for social distancing, to create a more safe space, to create or slow down the spread of the virus? Those are good questions that I can't answer. But I do know one thing for sure, that if certain people don't get out of that prison soon, they're not going to be able to come out, because they're going to be in a quarantine population. And, I don't know what's going to happen.
Okay, I have another question from Akila Lacey at The Intercept.
Mm-hmm.
The DA mentioned lists of people not eligible for release, including for drug offenses. Why is that?
Okay, the next question is from Akila Lacey at The Intercept. And the question is, the DA mentioned lists of people not eligible for release, including
Drug offenses.
including drug offenses.
Why is that?
And why is that? I would disagree with the characterization of what we are saying. This is a dynamic process in which, if we're trying to be efficient about reducing spread of the virus, we should be looking at the lowest hanging fruit, the most obvious categories for which not only there may be agreement between the defense counsel, in this case the public defender, and the district attorney, but we're liable to get agreement from the court because ultimately it is the court that will release. And therefore, the first group of lists, these 7 lists, was imagined in that way, as being ones where not only might the defender and the DA agree, but the judges would almost certainly agree or see it the same way. The process involves going to additional lists and additional groups of lists. You take the lowest hanging fruit, and then you go to the next pile of fruit, because it's just necessary. The public health requirement is that big. But we're never going to get to the next lowest hanging fruit if we can't even get through the lowest hanging fruit. And now I'm going to defer to the public defender to state with her response.
Yeah, I think you should qualify drug offenses too, Larry, because number one, if we have people in there on technical violations for drug use, where they were originally on probation for drug use and now they're in on a detainer for continuous drug use, that seems to be like an oxymoron to our proposal or our agreement that there may need to be safe injection sites because it saves lives for drug users. We should not be treating these populations when it comes to saving lives differently, right? We were just having a huge conversation about the fact that safe injection sites are needed for people that are using drugs and are dying because of it. Well, now we have people in jail that are in jail for using drugs, on detainers for using drugs more continuously. And now, because of this virus that has the potential of death, we are in another life or death situation. So if we're talking about drug usage, I think that those people definitely need to be looked at, because that would be an oxymoron for our city to say that those people should not be out.
And just so we're clear, I don't disagree with that. I think that's exactly right. And the DA office's position on possession of drugs, for example, has been, we want everybody diverted, everybody who's willing to do it. But we also have to be strategic and realistic about what it means when a sweeping and rapid approach to this encounters a certain amount of resistance. We have to try to take step 1 before we take step 2.
The next question is from Samantha Malamed at the Inquirer. She is asking if you are aware of reports that there was a riot at Pick, which is one of our county facilities.
So the question is from Samantha Malamed, and the question is whether I am aware of reports that there was a riot at Pick. The short answer is no. When is that report? And if you have information, we would love to hear it.
Here.
Our public defender. She's still muted.
I can say this: I don't have a lot of information about what's going on in the prisons. Unfortunately, I wish we did have more so that we can really express the urgency to the courts. I don't know if the courts know everything that's going on with the prisons. The only thing I really get at this point in terms of what's going on with the pandemic and the people there are from some of the clients that we're able to reach out to that are expressing that some frustrations without having certain equipment, masks, gloves, things like that. But I do hear that they're giving those today. I get most of the updates about the prison from the mayor's press release, in terms of the spread of the virus, how many positive tests or cases that they have daily. But I haven't heard about a riot in the prison or at Pick at all.
The next question is from John Mitchell at the Philadelphia Tribune. He has a 2-part question. The first is, what are the courts saying is the reason for the limited number of judges and courtrooms offered up?
Okay, the question is from John Mitchell at the Tribune, and the question is, what are the courts saying is the reason for the limited number of judges and courtrooms offered up? Honestly, I can't answer that. I would be speculating as to what they would say are the reasons for that. I do think in fairness to the FJD, it is worth bearing in mind that when you have court proceedings, there needs to be a record. So they may be dealing with issues of making decisions about whether to have a court reporter or simply use Zoom record mode, which we're doing now, which is another option. They may be dealing with issues of having court clerks. But I think a lot of us who pay taxes, and I, by the way, have been married to someone who was a judge in Philadelphia for 19 years. And as it happens, our public defender is married to a judge in Philadelphia right now. I think a lot of us feel like those of us who have a paycheck, as I do, those of us who are supported by taxpayers, we have an obligation, especially when we see how hard taxpayers are being hit by loss of jobs, by inability to afford housing and food. We have an obligation to do everything we can as our paycheck comes in. Let's go to the public defender, please.
John, I can tell you this. I know that there are judges that want to work. Our office our lawyers were reaching out to individual judges, and individual judges were reaching out to us before we had a process by which we were able to start doing this. And then we were told to stop reaching out to individual judges because it was getting overwhelming. So I know there are judges that are willing to help. They have been reaching out and providing guidance, but it's about the mechanism and the process that's willing to be created for this to happen. And I don't know who that falls on or what the mechanics are of that, but I do know for a fact, and I'm not just saying this because I'm married to a judge, I really do know that, and Larry was on the call when we were told to stop reaching out to individual judges because it was becoming too overwhelming, getting emails from all judges about different motions and different things that our lawyers were asking about.
And the second part of John's question, does the low number of judges and courtrooms they are recommending indicate that the courts are not taking this seriously?
The second part of the question is, does the low number of judges and courtrooms indicate that the judicial leadership is not taking the situation seriously? I don't want to judge judges like that. I think that's unfair to presume that I know how they think about this. We want nothing more than to work with them to solve this problem, regardless of what has happened in the past. But we also recognize that timing is important. The first case in the jails was March the 27th. By April the 2nd, there were 20 positives. And by April the 3rd, we have 31 positives and we have 15 pending tests. These tests, as I understand, are coming in fairly quickly, and the prisons are coming in about 12 hours. But perhaps the most alarming statistic of all is that, to our knowledge, there are 0 negatives among the people who have been tested. So timing matters, and everything we can do now is really where we need to focus. Let's go to the public defender.
Yeah, I don't really have much more to add to that. I don't want to say that they don't get the severity. I don't know what their process is, the things they have to make sure that they consider in terms of all the logistics. But I do know that I wish they would take us up on our offer to work tomorrow, to work Sunday, and we will do that if they allow us to. We will do that.
Third question from John at the Tribune.
What is this about Roebuck's question?
How much has been filed? 400
Okay.
e-filings.
I'm sorry, am I muted or am I?
No, you're.
I'm free. All right, I'm trying to answer Mr. Roebuck's question here. I have a note from Liam Riley, which says I have 405 e-file notifications. Some are refilings. Some have multiple docket numbers per person because, of course, an inmate may have more than one docket number, more than one case. An e-file notification, I'm sure you all know this, but I'll say it anyway, is an indication that a motion has been filed and notification that has occurred. So as the public defender mentioned earlier, there were a certain number of cases that had to be refiled because not only were we told no streamlined approach up front, but after the emergency powers came into effect, judicial leadership said, now you need to refile all of those motions because you filed them with the individual judges that applied to those cases before, but now all of the decision-making has been consolidated in this much smaller number of judges who are judicial leadership, and therefore, as a technical matter, they required everyone to refile the same motions before the judicial leadership judges. I'm not here to tell you that's good or bad. I'm just here to tell you that that affects the numbers, and it also affected the number of judges who were initially available, because essentially the power was given to judicial leadership to decide what other judges could do anything.
Third question.
Hang on one second. Is nothing? Okay, thank you.
Third question from John Mitchell. Has the Department of Public Health had any input in these processes?
Okay, the third question from John Mitchell is whether the Department of Public Health has had any input in these processes. To my knowledge, no. Public Defender Gray?
I'm not sure what the Department of Public Health has had any conversation. The only people that we've been in conversation with, I guess, on a more, I don't know, I don't want to say consistent basis, other courts. We did talk to the Department of Behavioral Health to help us strategize who needs to come out and who needs programming and treatments, but that's about it. I haven't heard anything about the Department of Public Health that will kind of let us know that we need to be doing certain things pretty rapidly. Haven't heard that yet.
The next few questions are from Max Mitchell at the Legal Intelligencer.
Okay.
First, he wants to know if the new quote-unquote protocols announced by the FJD today still involves filing motions individually, which seems to be a major part of why everything is moving slowly.
So these are questions by Max Mitchell, and the first question is whether this protocol, I assume Mr. Mitchell means the one indicated in the FJD's press release, the one we've been talking about, requires the filing of individual motions. The answer to that is no.
For those 360.
But the answer to that is no, thank you. But the courts are still permitting the filing of written motions for people who are outside of these categories. In fact, I think they're generally permitting the filing of motions. So, you know, I guess a piece of good news is that even though our feeling, and I say this respectfully to the courts, is that this should be a broader and quicker process, this is additional to the current case-by-case written motion process that exists now. PD Gray, you got anything? No. Second question from Mr. Mitchell.
He wants to know if the talks are ongoing. Obviously, that's yes.
So
okay.
Mr. Mitchell would like to know if the talks are ongoing
To change the protocols.
to change the protocols. I would say, God, I hope so. You know, my phone is on all night and my email works. So I certainly hope so. And in my most recent email, I think, in which I was confirming some of the details of what the court had decided, which we view as very constructive, although we wanted something broader and more sweeping. I raised the issue again. I asked the court if they would reconsider doing it more broadly and doing it with more resources. Public Defender Gray, you have anything that you'd like to add?
Yeah, not only did you ask that, I think around 6 o'clock last night, I know a member of the defense bar who was on that call did respond to Larry's email urging the courts to do just what he asked, to consider these classifications and to consider doing them expeditiously. I've joined that request. I really do think that we can get this moving even quicker if we start just looking at those populations, those classifications, and going through them in a fashion that allows us to go one by one in one setting. And I think it can be done. It's not like it can't be done. I should say this, early on in this process, we had tried one list option when we were still going to court with Judge Dugan, president of the municipal court. We had a list of people that were in on, I think it was $50,000 bail or less. By the time we got to effectuate that list, many of those people were bailed out by the bail funds, which were appreciated. So we only had to go through a few of them. We know that these things work. We know how it happens. We can just repeat the same process. Since that one list, we were not able to do lists anymore. After that one list with the municipal court, President Judge Dugan, we were then told that all other hearings would be done by petitions. And I think only 2 days ago were they willing to agree again to looking at lists once we said, hey, we really need to classify and categorize people to get them out more expeditiously, given the fact that there are now new positives in the jails.
Third question from Max Mitchell. Do you have comment on the Supreme Court order today rejecting the ACLU petition for King's Bench?
Okay, third question from Mr. Mitchell is whether or not we have comment on the Supreme Court's decision to reject the ACLU's King's Bench petition, suggesting that the Supreme Court might address the frankly sweeping and statewide issue, which is what King's Bench petitions are for, of pandemic and the reality of having 45,000 people in state custody. I do have a comment on that. It's disappointing. It is disappointing in the same way that the Supreme Court's decision not to exercise its King's Bench petition power to consider whether or not the death penalty as applied in the Commonwealth of Pennsylvania is unconstitutional was disappointing. King's Bench petition jurisdiction exists for the purpose of addressing sweeping statewide issues that are likely to repeat. And when we have an issue like this, I don't know what could be more sweeping and more statewide. I will conclude that comment, and I'll leave it for Public Defender Gray if she has something to say.
I would just say I agree. It is disappointing. That's all I can really say. Nothing else that needs to be said because it is what it is at this point.
Okay, is there
Fourth question for Max Mitchell.
fourth question for Mr. Mitchell?
Are the offices working with the governor's office to address the situation?
Okay, Mr. Mitchell's question, are the offices working with the governor's office to address this situation? My answer is sadly no. The governor has the power to use reprieve, which essentially means a delay in a sentence. It can also be a delay in an execution, which is the way the word is usually used, in the types of stories that media may cover. But what the word actually means is delay. And it is a power that this governor has unilaterally. It was a power that was written for extraordinary circumstances. These are extraordinary times. I call on the governor and have called on him before to use that reprieve power. Unfortunately, he's made it very clear that he won't. And the process that is being followed is one where the governor is claiming it is a matter for legislative determination. And as far as I can tell, we will get too little too late a Republican-led effort to let next to nobody out. So that is not something that makes Pennsylvania residents safe when you have incubators for this virus all over the state, and you have guards whose lives are in danger who go in and out, correctional officers, medical personnel who go in and out and who interact with other people. That is a way to spread the virus. I think it's very disappointing to see so many elected officials and so many people in different types of leadership who could step up right now and do something that might not be politically risk-free, but is the right thing to do. And yet, that's what we're seeing. We're seeing an attorney general who opposes the King's Bench petition. We're seeing a governor who has the power to do something and won't, and it's disappointing. Public Defender Gray?
Yeah, I will say that, and I don't know, I kind of echo what Larry's saying. I don't know what we're going to need here to really give people an understanding of what we're talking about. Are we going to need a person profile to help them understand who is in that prison right now that does not need to be, who is not a danger, so that they really get that we're not, these are people that we're talking about that would be out if the courts were functional. That's what we're dealing with. These are people we're talking about that would be out if the courts were functional, but because the courts are not functional, they have no way of getting that access to the courts to allow them to get out the way they should be. Secondly, I just want to put this in your purview. Members of my staff, and as well as the DA, met with the courts on March 9th. That was the first time we met with them to discuss this issue. And the first positive COVID case at the prison was on March 26th. 3 weeks went by where we could have been doing these things. 3 weeks. And I hope that we are on track to do it in the next 3 days, if we can, because we are available to do it then. I think that's all I want to leave on, is that we have got to start moving more rapidly. The people in that jail do not deserve to be treated like this. They are not getting their rights, met because they are not able to address the issues that they would be able to address if the courts are open. The whole issues stem from the fact that the courts are closed and cases and people are not moving because of that.
All right, am I unmuted? Yes, okay. I don't know I think we're coming to the end of this. I don't know if there are any other questions. We are, but I do want to say this to you. You know, ordinarily, I don't really view it as appropriate material for the media in the ordinary case to review emails with other stakeholders about a particular issue, but the truth is the truth, and the record needs to be correct, because we all need to be accountable, including my office, for what we do and we don't do. The private bar has participated in this process. They have not only participated and expressed themselves, but they have witnessed it. And so, for example, Ronald Greenblatt was present at one of the more important meetings, the meeting that happened on the Thursday prior to the closing of the courts, where Public Defender Grey was actually represented by Alan Tauber, her first assistant. Mr. Tauber, Ron Greenblatt saw exactly what was said and what was not said in that meeting, which was attended by members of judicial leadership. Troy Wilson was the private attorney that Public Defender Grey referenced, who was in the most recent conversation. And so there is not only validation and verification of where the defense bar and the prosecution stand in terms of trying to move this thing along swiftly and in a broad way, but there's actual confirmation of the details of what Public Defender Grey and I have said about this process. Is there anything else, Jane?
Nope.
All right.
No other questions on this topic.
Thank you all. I really appreciate your interest in this topic, and special thank you to Public Defender Grey for rearranging her schedule so we could answer these questions. Thanks very much, and have as nice a weekend as you can. Bye-bye.
Thanks, guys. Thanks, Larry.